The Supreme Court heard arguments today which could strike at the heart of the administrative state. Chevron Deference has faced its first real challenge in years at the hands of two cases brought by New England Fishermen. Amid a historic and record setting win in Iowa by Donald Trump in the Iowa caucus, one of the most important Supreme Court decisions in the past decade is approaching its final stage, and yet it's been widely ignored. The decision of the court in Chevron USA Inc. versus Natural Resources Defense Council of 1984 shaped the importance of regulatory agencies in the decades following. That 40-year reign of unrestricted regulatory rule for federal agencies may be ending, however, due to the two cases that were heard by SCOTUS today. To begin, however, what is Chevron deference? The court held that federal agencies, in the case of Chevron, it was the Environmental Protection Agency, have the right to interpret the roles Congress gave them in the event of any ambiguity in the directions that Congress laid out. In the words of Justice John Paul Stevens, who penned the unanimous decision in Chevron, quote, "When a court reviews an agency's construction of the statute which it administers, it is confronted with two questions. First, always, is the question whether Congress has directly spoken to the precise question at issue. If the intent of Congress is clear, that is the end of the matter, for the court, as well as the agency, must give effect to the unambiguously expressed intent of Congress. If, however, the court determines Congress has not directly addressed the precise question at issue, the court does not simply impose its own construction of the statute, as would be necessary in the absence of an administrative interpretation. Rather, if the statute is silent or ambiguous with respect to the specific issue, the question for the court is whether the agency's answer is based on a permissible construction of the statute." End quote. Essentially, the Chevron doctrine emphasizes the principle that judicial bodies should defer to the administrative agency's interpretations of ambiguous laws, provided these interpretations are reasonable. This approach gives agencies leeway, or deference, as the name implies, in legal matters not explicitly addressed by Congress, recognizing their expertise and Congress's implicit trust in their judgment. The court goes as far as to float the theory that perhaps the reason Congress was not more specific in the laws they passed was because they wanted the administrator's interpretation to reign supreme. The decision further reads, quote, "In these cases, the administrator's interpretation represents a reasonable accommodation of manifestly competing interests and is entitled to deference. The regulatory scheme is technical and complex. The agency considered the matter in a detailed and reasonable fashion, and the decision involves reconciling conflicting policies. Congress intended to accommodate both interests, but did not do so itself on the level of specificity presented by these cases. Perhaps that body consciously desired the administrator to strike the balance at this level, thinking that those with great expertise and charged with responsibility for administering the provision would be in a better position to do so. Perhaps it simply did not consider the question at this level, and perhaps Congress was unable to forge a coalition on either side of the question, and those on each side decided to take their chances with the scheme devised by the agency." End quote. Although this may seem innocuous enough, there are serious problems with what this doctrine has allowed for over the past 4 decades. One of the first and most pressing matters raised by the court's decision in Chevron is its seemingly contradictory position to the Administrative Procedure Act, or the APA, of 1946. Since the APA, quote, "requires courts to determine independently all relevant questions of law, including the interpretation of constitutional or statutory provisions." End quote. This specification was made by Representative Francis E. Walter, the chairman of the House Subcommittee on Administrative Law at the time. These two ideas stand in direct opposition to one another. Following Chevron, however, the APA quickly faded into irrelevancy as these federal agencies chose to make decisions with the wide swath of interpretation afforded to them by the 1984 ruling. This ability to regulate with impunity has led to the drastic rise in red tape that has burdened American entrepreneurs for so long now. Overregulation was so important that it became a central promise in Donald Trump's first presidential campaign platform, which he delivered on, leading to the savings of $220 billion in regulatory costs. As Joseph Postel and Paul J. Larkin Jr. of the Heritage Foundation wrote, quote, "The Chevron and our deference doctrines raise serious constitutional concerns and are inconsistent with the Administrative Procedure Act, and have little basis in American legal history. They threaten to disrupt the separation of powers by transferring judicial power to the executive officials under the fictional assumption that Congress intends to give administrative agencies power to interpret the law whenever it creates a statutory gap. Judges do not apply the Chevron framework consistently, and this leads to confusion about the level of deference that agencies actually receive in practice. For all those reasons, it is time for the misguided deference regime to end." All this goes to demonstrate both a theoretical and tangible need for the court to overturn the Chevron doctrine once and for all. That brings us to the two cases on the docket for today: Loper Bright Enterprises versus Raimondo, and Relentless Inc. versus the Department of Commerce. Both of these deal with the question of the Chevron doctrine, are brought by those engaged in the herring fishing industry in New England against the National Marine Fisheries Service, the NMFS, and question the Magnus-Stevens Fishery Conservation and Management Act, the MSA. There's a lot of overlap between these two cases, which is why the court will be hearing them on the same day. The specific overstep the petitioners claim was that NMFS, National Marine Fisheries Service, forcing individual privately owned ships or their parent companies to take aboard and financially support the cost of at-sea monitoring. In the document published by the court notifying the parties that certiorari had been granted in the case of Relentless versus the Department of Commerce, the court wrote, quote, "Deeming annual congressional appropriations for the federal observers insufficient, the agency asserted a right to force the fishing vessels into contracts to pay the federal observers. The First Circuit approved this practice without stating whether its conclusion was a product of Chevron Step 1 or Step 2. It held the mere fact that the MSA provides for federal observers gave the agency carte blanche to charge the regulated party for those observers. Neither Chevron nor the MSA provision allowing these measures necessary and appropriate to enforce the statute allows this result." End quote. If allowed to stand, these increased costs will either put the fishermen out of work due to increased costs, or they will be forced to push those costs onto the consumer. The misuse of Chevron deference by current and previous administrations is evident in the way federal regulatory agencies have been able to impose restrictions, enact regulations, and subsequently levy financial penalties on businesses for the inconvenience that they have caused them. As the court hears arguments in both these cases, we have to hope that when their decision comes out later this year, it will reverse the 40 years of unchecked government red tape that we have endured as a result of the 1984 Chevron decision. Deregulation is one of the best ways to boost the American economy in a time when it is struggling, and SCOTUS can take a big leap in that direction with this decision. I know it's been a long time coming. Finally got my first video out. If you guys are interested in following me on Twitter, it's at Stoic American, where you can find my blogs and writing at americanstoic.substack.com. Thank you, and I appreciate you guys listening.